In the classic case of Hadley versus Baxendale, the court set forth foundational principles of contract damages. A breaching party is liable for general damages only if the non-breaching party's injury was reasonably foreseeable when the parties entered into the contract, and for damages stemming from special circumstances only if those circumstances were known to all parties when the contract was formed. Hadley's more than a century old, but its rules are still relevant, as demonstrated by the court in Hector Martinez and Company versus Southern Pacific Transportation Company. In February of 1974, Martinez delivered a dragline excavator to a railroad company for shipment from Ohio to Texas. Southern Pacific was the carrier responsible for delivering the dragline to Martinez's agent. Martinez expected the dragline to arrive in Texas by March 1st, but it didn't arrive until April 2nd. The dragline also had been damaged in transit, and Martinez had to repair it. The repairs weren't completed until June 20th. Martinez sued Southern Pacific in federal district court, asserting 3 claims for damages. First, for the cost of repairing the damaged dragline. Second, for a refund of storage costs charged by Southern Pacific. And third, for compensation for the loss of the dragline's use during the transit delay and during repairs. Martinez and Southern Pacific settled the first 2 claims, but Southern Pacific moved to dismiss the third. Southern Pacific argued that Martinez's loss of use claim sought special damages which weren't recoverable because Martinez hadn't notified Southern Pacific of the possibility of those damages. The district court granted Southern Pacific's motion to dismiss, and Martinez appealed to the Fifth Circuit.